chairman, but based upon my reading of the rules, any two commissioners can call the meeting to order. So I will move to call the meeting on December 19th to order, if I can get a second.
Second.
And we've got a second, so I guess maybe we'll take a vote. All in favor of calling the meeting to order, say aye.
Aye.
All opposed? The motion carries. The first order of business will be electing a new chairman and vice chairman. Commissioner Kathy has recently resigned, and Commissioner Adams resigned a couple months back. So I will move to open nominations for the chairman position.
Hearing the, well, I guess second.
Second. So we got a motion and a second. All in favor?
Aye.
Say aye. Aye. All opposed? Okay, the motion carries.
With the nominations now being open, I would just want to point out that Jake Evans is the longest serving member of the commission at this point. I think he's got certainly the necessary background and qualifications to lead the commission due to his time here and his involvement in many other activities. Therefore, with the period of nominations open, I will nominate Jake Evans as chairman of the commission. Are there any other nominations?
No other nominations, and I'll second that nomination.
I would move to close the nominations. Is there a second?
Second the motion to close.
Okay. The nominations being closed, I guess I'll call the vote. All those in favor of electing Jake Evans as chairman of the commission, say aye.
Aye.
Any opposed? Congratulations, Mr. Evans.
Thank you. Thank
You
you.
want to change seats?
That's right. Well, good. Well, thank you for that. So next we've got the vice chairman opening, and I will move to open nominations for the vice chairman of the commission.
Mr. Chairman, we have a request from our IT people. Would you mind activating your microphone? We're having trouble.
Absolutely. There you go. Should be. Is it activated now?
Not yet.
Not yet.
Chair.
Yeah, I hit it.
Is it solid or is it flashing?
It's red. I've got to turn up. Yeah, it's
No, it should.
There's a picture of
volume up.
Hello?
Oh, there we go.
There we go. Good deal. So do I have a second for nominations for the vice chair position?
Second.
All in favor? Say aye.
Aye.
All opposed? Hearing none, motion carries. And I will nominate Commissioner, tell me your name. I always want to just say Cranbull, but Cranbull. Commissioner Cranbull is the second longest tenured person on the commission. I think he's got the intellect and definitely the knowledge to take over as vice chairman, and so I move to nominate him. Do I hear a second?
Second.
Okay. Good. All in favor? Say aye.
Just a couple of questions.
Sure, real quick.
And I don't know if is mine on. Do you need to turn me on?
Which number are you? 23?
23, yes. Thank you, Mr. Chairman, and I understand and I appreciate the process we've gone through. We certainly need a chairperson and a vice chair. In terms of the tenure of the current appointments for the chair and for the nominee for vice chair, I guess my question is, what is tenure, your respective tenures? When do they expire? We're going to have to walk through this again in another couple of months. And I'm curious as to what your thoughts are in terms of, the length of the tenure, the appointment. Obviously, the governor-elect and lieutenant governor and others can appoint who they choose. Could you just give me your thoughts around that?
Sure. I mean, and Mr. Ritter may be able to opine on this as well. To my knowledge, for each of the commissioners have a term. I think the term is 3 years. Is it 4 years? Okay, the term is 4 years, and so as far as staying in the vice chair, chairman position, I don't, Mr. Ritter, do you know if it is an exact term for?
No, it's not, and I think it's as long as you serve, unless someone else is elected, you're going to be the chair. Just to remind everybody of where we are in terms of terms, right now Mr. Barnum has been appointed to a full term, so he just started that. He'll be in position for several years, unless he resigns, whatever. The other 3 members of the commission right now who are still serving, all are subject to reappointment. That is, you're filling somebody else's term, but you haven't served a full term yourself. And everybody's entitled to finish a term if they're appointed to fill someone's term and then get their own term. But only once can that happen. And all of those are going to become an issue by the end of March of this year, really before that. And I have no reason to think that you wouldn't be reappointed to your terms. Mr. Evans, you're an appointee of the governor, so you've got a new governor, and you know, if he were to appoint someone else, I think the commission would need to elect a new chair at that point. Mr. Cathy's position is one that he was a holdover in, so Mr. Cathy can be appointed at any time, either by Governor Deal or by Governor Kemp when he takes office. So that's the status.
Thanks, and thank you, Mr. Chair. So, Mr. Ritter, I just want to clarify, at least from my understanding and the understanding of the commissioners, that if we proceed with these appointments or elections that we're considering right now, and assuming my colleagues are reappointed to their current positions, then these appointments as chair and vice chair will be holdover appointments. They'll continue in those roles. If they're reappointed, we may or may not have to go through this again.
That's right.
Okay.
I think that's right.
Okay, all right, thank you. My questions have been answered.
Thank you. Those are good questions. I appreciate that. And so we've got a nomination for Mr. Cranfield. Do we hear, is there any more nominations for vice chair? Does anyone want to move to close nominations for vice chairman?
I'll move to close nominations.
I'll second that. All in favor, say aye.
Aye.
All opposed? Hearing none, the motion carries. Commissioner Cranfield, congratulations, you're the only nomination. And so by default, I will move to appoint you as the vice chairman of the commission. Do I get a second?
So seconded.
All in favor, say aye.
Aye.
Okay, good. So the first topic is the commissioners have been apprised of a new issue yesterday. I think I would move to amend the agenda to add executive session to the end. We won't have that until the end of the meeting, but I'll move to add that to the agenda. Do I get a second?
Seconded.
With greatest respect, we can do that if there is an emergency need for the executive session. I don't know what it is, but I will say that the reason for the executive session has to be stated by the Open Meetings Act. I don't think you have to be elaborate about that, but I will say you've got to state some reason for the executive session. And you can't do it to consult with an attorney if you are in an open meeting. But what you can do is you can have an executive session to to discuss litigation that's ongoing, and very few limited other exceptions. And just background, the current open meeting and open records law, the first draft of that I drafted. I also wrote part of the red book that is currently the guide for that. I'm not trying to be difficult, I'm just pointing out that there's issues there. So if you have an open executive session, of course I'm not going to object to that, but we do need to do it appropriately.
Sure, I understand. Mr. Fuller, do you have any comment on it?
I would echo Mr. Ritter's position that just a brief reason needs to be stated just to go into executive session. It doesn't have to be elaborative, but the board obviously can choose to amend the agenda to have an executive session. So just a brief characterization of what the board believes executive session needs to be at for.
Sure.
And I'm not 100% sure, but I believe one of the reasons for going into executive session, and someone can certainly correct me if I'm wrong, because I'm not giving the board any form of legal advice, is to discuss personnel issues. I think that's one of the
Right.
reasons.
That's right.
Okay.
Except that as far as my position, I assume that's not an issue, but as far as my position, there are certain issues as to what you can and cannot do in executive session regarding the head of the agency. That's, okay, and we can pull up the law if necessary.
Sure. Well, so we've got a motion and we've got a second. I will amend the motion to say we want to amend the agenda to add executive session to discuss personnel issues. Do I have a second for that amendment?
Second.
Okay. Any discussion? No discussion, so I will call the question. All in favor, say aye.
Aye.
Aye. All opposed? Hearing none, the motion carries. So next we've got the meeting minutes. The first issue is for the June 21st, 2018 minutes. I don't think we have a quorum of people who were there as far as the commissioners, given we've had 2 resignations. We've had discussion on de facto adopting the meeting minutes as far as they were written. I believe they were video recorded. And I wanted to open this up to the commission to see if they had any thoughts on adopting these, tabling it, or just taking no action.
The only thing that I can really comment and say about that is again, we're going to be in a position where we can't formally, we will never have a quorum at this point to actually approve those minutes. I don't think that certainly invalidates anything that occurred, at that meeting. Again, we've got the video recording of it, and we've got an audio recording of it. I tend to believe that the only solution to this issue is to just have the minutes stand as they do, without a formal approval, with just a recognition that we will certainly abide by what are in those minutes and what's in the record. Would that be appropriate, Mr. Bull?
I believe
What line are you?
16.
16. Got it.
I'll just speak.
Loudly. Oh, there we go. I believe the board can move to adopt the minutes, even though the individuals there wasn't a quorum of the individuals who were present at that previous meeting. The existing board, if there's a quorum present now, can adopt meetings of the previous meeting, the previous commission board meeting.
Okay. The commissioners have any other comment? Okay. Do I hear a motion to adopt the meeting minutes?
Mr. Chairman, I move that we adopt the minutes from the June 21, 2018 meeting, and have the minutes stand as adopted.
Do I hear a second?
I'll second.
The motion having been made and seconded, I'll call it. All in favor, say aye.
Aye.
All opposed, say nay. Hearing no nays, the motion carries. The September 20th meeting minutes is next. Did everyone have an opportunity to review those meeting minutes? Was there any proposed corrections to the meeting minutes? Hearing no corrections, I will move to adopt the September 20th, 2018 meeting minutes. Do I hear a second?
Second.
I'll call it to question. All in favor, say aye. Aye. All opposed, say nay. Hearing no nays, the motion carries. So the next thing on the agenda is Mr. Halliburton's lobbyist appeal. I've been informed that he has withdrew that, so we will remove that from the agenda. And then next up, we have the preliminary hearings. Is there anyone here today who is representing any of the candidates or any of the candidates here today?
You have 2 candidates here, sir.
Okay. In the sake of efficiency, I think we will let the candidates who are here first go before the commission. And so your name, ma'am?
Dawn Johnson.
Don Johnson. And then Mr. Chalmers, who is your client?
Mr. Chairman, we have Ben Watson, but I believe we may be moving that to a consent order.
Okay. Well, then we'll go forward with Ms. Johnson, and I don't know,
And then
excuse me, ma'am?
LAPIO, L-A-P-I-P-O.
Okay.
Letter F.
Oh, LADPO, right. Well, Ms. Johnson, we'll go with you first, and I'll let the commission present, and then I'll give you an opportunity, Ms. Johnson, to respond. Whenever you're ready, Mr. Lane.
Thank you, Mr. Chairman. Commissioners, you have before you today case number 2018-0055 in the matter of Ms. Dawn Hawkins Johnson. The commission accepted a complaint from Mr. Kurt Shook on or about June 12, 2018, wherein Mr. Shook alleged that Ms. Johnson failed to file her campaign contribution disclosure report for January 31st, 2018 and March 31st, 2018, both would be violations of OCGA 21534C2A. After review of Ms. Johnson's campaign contribution disclosure reports, we found that those allegations were unfounded. Ms. Johnson properly filed her CCDR. She properly disclosed what her campaign contributions and expenditures were. Unfortunately, during our review, we did notice that there were two additional violations that need to be noticed. The first, which is, it's a serious violation, but not in actual practice. It was Ms. Johnson began accepting campaign contributions prior to the filing of her declaration of intention to accept campaign contributions. That DOI is the document that allows candidates to begin raising and spending campaign cash. And that's pursuant to 21530 subsection G. When I say it wasn't that serious, Ms. Johnson spent a grand total of $42 prior to filing the DOI, and it was to create a campaign logo. So that's why I said it's not like she raised thousands of dollars and just didn't bother to deal with the DOI. The second violation was that Ms. Johnson filed her personal financial disclosure statement for calendar year 2017. She filed it late. As the commission knows, pursuant to 21550 subsection A1, candidates, when they qualify for office in their election year, have to file that disclosure within 15 days of qualifying. Ms. Johnson's disclosure was due on March 20th, 2018. She filed April 5th of 2018, so she was late. There's a corresponding late fee of $125. Contained within her personal financial disclosure statement, it was correct as far as we could verify through our database system, as well as through LexisNexis's database system. She seemed to disclose all of her financial holdings, so we saw no issues there. We notified Ms. Johnson of the two additional violations, or the only two violations, that being expending money prior to the filing of the DOI and then the late filing of the FDS. And those are the two violations, Commissioners.
Okay. Ms. Johnson?
Well, I would like to say first that the reason that the initial report was filed was because I mysteriously vanished from the searchable engine on the Ethics Commission. I had a 2017 number. After qualifying, I had a 2018 number assigned to me without any knowledge. And so when you looked, it looked like I had never filed a single piece of paperwork. I have never received any explanation as to how I spent 6 or 7 months on the website and then was removed and then assigned a new number without filing any paperwork. So that's what generated the initial complaint. The claimed campaign expenditure fundraising was a personal expense out of my personal checking account, and the logo was not displayed or used in any way until after my paperwork was filed. And the reason was, I truly was not certain I was going to be able to run My husband was diagnosed with a brain tumor that month, and I wanted to make sure that I would be able to have a candidacy. I didn't want to take anyone's money. I waited several months after filing paperwork to even take a donation. I only used my personal funds. So I was trying to be diligent in being a steward of other people's money and in keeping with the law. So the law says that you are a candidate and you have a campaign expenditure when you have created an expense with a view to seek a nomination or election. If the logo was not displayed in any way publicly until I had filed paperwork, and because I wasn't even sure I would file the paperwork, then how did it in any way assist me in running for office? But when I did use the logo, I, in abundance of caution, put the expenditure in the reports because I wanted to be forthcoming in all of my reporting. But if I had never run for office, it would have never even been seen publicly. So I don't understand how this $42 expenditure rises to the level of illegal fundraising when it wasn't used in any way until after the funds, were properly obtained and until I had officially decided I was going to run for office. So, these were nuisance complaints. This individual filed multiple complaints against all of the Democratic candidates running in Athens so that they can use the Ethics Committee as a de facto political arm of the Republican Party. It is an intent to suppress candidates who are not lawyers or accountants from running for public office. And the reason I chose to run is because the seat had been uncontested for 6 years, and that is not democracy. And trying to make, twisting of language and abuse to intimidate people so that they won't take part in political progress in the state is, I think, an abuse of the position. And I think that it probably would warrant Freedom of Information Act requests to see how often this happens. How many blanket complaints are made by one person in the Republican Party of Georgia against all candidates, and how many people have to take time off of work, drive 2 hours up here, and sit. Now, I misread the code for the filing of the personal, finance declaration. I actually filed the year before when it wasn't even due, and I thought it was 30 days. It was 15. I've never contested that, and we said we were more than happy to pay that fine if this particular complaint was dropped, because it seemed unreasonable and it didn't seem to even meet the law. And so that's why I'm here today.
Well, thank you, Ms. Johnson. Thank you for coming. It's important for you to come. And I want to give Mr. Lane an opportunity to respond just to the legality. That's all that we're concerned about. And I want to give each of the commissioners an opportunity to ask any questions that they have.
Sorry, may I add one thing?
Sure.
If at any time if a candidate even thinks about running, and then they expend any money. For instance, I put gas in my car to drive up to file the paperwork. By this interpretation of the law, I illegally fundraise money because I put gas in my car to drive up here to file paperwork. If I put a stamp on it, I have illegally fundraised money because I used it with an intent to gain public office. If I attended a lunch with somebody and paid for it. I went in January to a Georgia Windless lunch. Was that a campaign expenditure that I paid out of personal money because I was thinking about running for office? At what point does this interpretation end? At what point does a reasonable person look at this and consider something an expenditure? And I would think that this would not pass a reasonable expectation unless I immediately started using it at the same time in public to advance a campaign.
Sure. Thank you, Ms. Johnson.
Thank you.
Commissioners, I understand Ms. Johnson's concerns, and I respect them, and I respect her arguments. What I can tell the commission is that Georgia law takes a very bright line and hard rule as to what you can spend and what you can raise prior to officially declaring your candidacy through the filing of the DOI. Unlike our federal elections code, where you can spend money, you can raise money, you can quote-unquote test the waters, you can pay for polling to see if you have a viable candidacy. You can spend money to get campaign staff up and running so they're in place so you can hit the ground running the moment you file. Georgia doesn't allow that. Georgia's very clear in 21.530 subsection G that you are not allowed to accept or expend campaign funds prior to the filing of a declaration of intent. Now you also have to look at code section 21.5.3 subsection 12, which explains what an expenditure is. And our General Assembly has made it very broad, and they have said That is pretty much anything you spend for the purpose of influencing an election or seeking an election. Also, the definition of candidate in 21.530 subsection 4 is also broad. It's pretty much anyone who's seeking nomination or election to office. I understand Ms. Johnson's concern, and she kind of made the slippery slope argument of where do you cut it off? If I take someone to lunch because I'm talking to them about wanting to run, does that count? And I would say no. But what this commission has always done in the past, and of course it's always subject to change with new commissioners, which we have, that if you are making expenditures that directly tie to your campaign, you're paying for polling to see if you have a viable candidacy, that counts. You're paying for campaign staff, that counts. You're paying for campaign logos, you're paying for campaign signs, you're paying for campaign, push cards, what have you. Anything your campaign is going to be using, in my understanding, and Ms. Johnson can correct me if I'm wrong, she used the campaign logo. Now, we're not saying she's a bad person or that she did something bad. As I've told you, I thought it was a fairly minor infraction because she spent $42 on a campaign logo. I don't think she's a horrible person for doing so.
Have you guys considered, has a resolution been discussed, and if so, what are we talking about?
We have discussed the resolution, and as far as I recall in my back and forth with Ms. Johnson, like I said, she can correct me if I'm wrong. The back and forth was that the complaint needed to be dismissed, and that was the end of the matter. Unfortunately, that was something I could not agree to. As far as the fines, mainly the fines would be related to the filing of the personal financial disclosure statement late. As the commissioners know, that comes with a $125 fine and generally a $100 civil penalty.
What's the civil penalty?
So the civil penalty would be $100,
Okay.
followed by $125 late fee.
So 225 total?
Yes, sir. Now, of course, the original consent order that we always give out, the numbers are slightly inflated, so we have some wiggle room, because of course, if we give the bare minimum offer, we always give the half out zero, so we have nowhere yet.
Ms. Johnson, what is your thoughts on accepting a $225 fine? Is it about principle?
Well, we offered to pay the late filing weeks ago. There was the additional $150 and $275 fine for the logo that we contested because it wasn't used, because at that point there was no campaign. Literally the campaign constituted a logo in a folder on my computer that had never been shown to anybody.
The original, let's see, the consent order that was sent to Ms. Johnson was a $150 civil penalty and a late fee of $125 for a total of $275. As I told the commission, it's slightly inflated to allow us to say, hey, we're giving you a break. The civil penalty's down to $100, the late fee remains at $125. Because as the commission knows, I can't waive the late fee or reduce it. That's within your discretion. But y'all do give me a little ability to move around the civil penalty.
So it seems to me the issue before the commission is and I encourage both of you guys to correct me if I'm wrong, but if you hire someone to make a logo which is not publicly displayed prior to declaring your intent, that is spending money to further candidacy.
Because, Mr. Chairman, look at it this way. What if you pay someone to create campaign signs for you, but you didn't put them out, you kept them in your garage until such time as you filed your DOI? You'll have candidates raising money and spending money that could be greater than $42. And we have seen that. We've had cases before this commission where someone will spend $3,000, $4,000 prior to the filing of a DOI, and they'll come in here and say, I was just testing the waters. I wanted to run a bunch of polling. Well, under federal law, that's allowed. Under our law, it's not. I wish we had a testing the waters exception. I think it would be a good idea, but unfortunately, we don't.
Ms. Johnson, do you have any authority to support the position that spending money to create a logo for a campaign, even though it's not publicly displayed, does not qualify as furthering your candidacy?
Well, it says it has to, with a view, the way the actual, well, let me look because I made a note of how it was worded, with a view to advancing an election or nomination. If no one sees it, and it's not, I'm not raising money from people. This was a personal purchase. So I don't understand how that advances an election or a nomination if it is not used in public. If I went and spent $500 on yard signs and kept them in my garage and never ran, how does that advance the view to a nomination or election? Or if let's say if I decided I might want to run for governor, and I bought the Google domain Dawn for Georgia, so nobody else would have it. That would, in this interpretation, I would be in violation of campaign finance law, even if I never ran for governor, which seems unreasonable.
Is that your understanding? And I'm particularly interested in the examples that Ms. Johnson has given. Let's talk about the
Sure.
Dawn for Georgia example.
One of the things I heard, and I'm not trying to dodge your question, but she keeps referencing these are personal expenses. And the way our law is written, a candidate making personal expenses towards their campaign is a contribution. And many candidates, both Republicans and Democrats and Independents, fall foul of that. Generally, we're told, well, I don't understand why I need to report these because they're personal expenses. Well, they're contributions in the eyes of the Campaign Finance Act. You can spend as much money of your own on your election. As far as for the Dawn for Georgia example, I would be willing to say that it would be a campaign expenditure because you are reserving it for the purpose of seeking higher office. You're doing it for the purpose of reserving that for a future campaign. There's nothing in our code section that says that that expenses are only within a year of deciding to run count. Under our law, I could technically file a DOI right now for my gubernatorial run in 30 years.
So, I'm sorry, go ahead.
No, go ahead. So it would be nice if the code were parsed down to say, maybe a 2-year look back or a 1-year look back or a 6-month, whatever the General Assembly thinks is fine for expenses in anticipation of a campaign. Because most people don't start raising money until maybe a year out for the higher offices. But there have been cases we've had where there have actually been people who've raised money for 4 years. I know the district attorney currently in Paulding County, prior to his run, began raising and expending funds 4 years before his campaign.
So does the use of personal funds, whether it's reserving a domain name or creating a logo or hiring someone to create a logo, does the use of personal funds become a campaign contribution once the person decides to run for office? Or does it become a campaign contribution if the person never decides to run for office?
That's unfortunately, you have to look at you have to look at the circumstances surrounding the expenditure.
Okay.
For example, in Ms. Johnson's instance, if she had never run and never used the logo, of course, I don't think we would be arguing it was an expenditure.
Because she was never a candidate.
She
for
never
office,
was a
right?
candidate.
Okay.
She just has a logo she can use.
Right.
In this instance, she used the logo, which I think shows that she had an intent to run at the time she made. You're kind of looking at the circumstantial evidence of, it's hard to say I made this logo with no intention to run, because she ultimately did run fairly quickly thereafter, and the DOI came shortly thereafter. This isn't a case where she paid for the logo 4 years ago and then decided to run 4 years later. If I recall correctly, the expenditure was maybe 2 or 3 weeks later. So it's really close in time. She ultimately did run 3 weeks later. She did use the logo. I like in my 30-year example, if I get a campaign sign that says Robert for Governor 20-50, and I never use it, I don't see that being a campaign expenditure. That could just be like a novelty sign. We're not looking to.
So then, if we're looking at the facts and circumstances, is it your view that there is an element of subjective intent that we have to infer?
I don't think the code has an intent statute, but I think for the purpose of fairness, y'all should look at subjective intent on whether they did or did not, because like I said, I don't want to go down the road or have the precedent of someone with a novelty sign that they created for something 30 years down the road. Sorry, I don't think we need to go down that route.
And I think it's important to remember too, the question before us, and the question before us is whether we have reasonable grounds to believe the Campaign Finance Act was violated. So we're not the final arbitrator here. So if we say, yes, there's reasonable grounds to believe, you then go to a next proceeding, OSHA, who then will make the final determination. And I say that to say that our standard is a little lower. And there's some people that come before us and say, listen, this is a matter of principle, it's not about the money, I'm not gonna, there's other people that say, I'll just pay $225 and put it behind me. Now, whether or not you want to make an agreement to that or make a consent agreement and then put this behind you is up to you. But, you know, I just want you to understand the standard for us is whether there's reasonable grounds to believe. And there may be a possibility there are reasonable grounds to believe. And sometimes Mr. Lane and Ms. Wells will talk to people and try to resolve it. And I don't know if that's something you would want to consider.
I mean, yeah, but if we're looking at intent, the difference between when I had the logo created and when I filed was the results of my husband's brain biopsy. And when we knew it wasn't cancer, then I knew that I could go ahead and run. That was the precipitating factor. If it had come back differently, I would not have run. And so it's not like, oh, I did it and then frivolously a few weeks later decided, yeah, I'm going to run. We had something that came up and I truly was not certain I was going to be able to run for office. And so once that changed, I filed all my paperwork.
If the logo wasn't created for the purpose of running for office, what purpose did it serve?
Well, it was created if I was going to run. But at that point, I wasn't certain I was going to be able to.
But there's no other purpose that you would have used the logo for.
No, but it also wasn't displayed publicly until I actually was running. So it also, if it's never used or isn't used until you have filed all your paperwork, then is it actually a campaign expenditure? If there is at that point no campaign. And if this is something that everyone needs to know, then I think the law needs to be written clearer so that it is not, you know, something that other people get surprised with and find later. Because, you know, a lot of people buy domains. And if they do, and now they're in violation of campaign finance law, and they're going to be pretty shocked to find that out.
Only if they end up running, from what I've heard Mr. Lane say. I mean, the example that you gave earlier about, you know, oh, I think I may, you know, run for governor, so I'm going to make a bunch of signs. And again, I think what Mr. Lane said was that if you don't actually ever declare your intent to run for governor, then that wouldn't turn out to be a problem. I mean, I can remember in 8th grade, you know, making a sign that my friend and I were going to run for president in 2016. You know, and I don't think that would, you know, amount to a campaign violation. I think here the significance is that there was no reason for this logo other than to run for office, and it was ultimately used as part of your campaign.
Can I get a clarification on the timeline? Ms. Johnson, was the logo, I know we've been talking about the logo being used or appearing publicly. What's the timeline? And perhaps you both can speak to this. Did the logo appear or was it used publicly and then you filed your declaration, or the other way around?
It was the other way around. I didn't use it publicly until I filed my paperwork.
My understanding is that the expenditure was reported as January 31st. The declaration of intent was filed with our office February 11th.
Okay.
I honestly can't tell you when her website went live. I'm not entirely sure.
Not until this year.
Oh, yeah, right. But
Okay. Thanks.
Any other questions?
And we still there is one issue of a violation of the act, if I'm understanding this correctly, that is not even in dispute.
correct. The
Yeah.
filing of personal financial disclosure statement. And
And that's not in dispute.
It's not in dispute. and
But
that's-
y'all can't resolve the matter because of the other issue.
And that's the only issue that's being punished, is the filing of the PFDS. Like, if you look at the amount of fines that are being proposed, the standard fine for expending money prior to VOI is closer to $500. And no one's ever asked for that.
What I would propose, if I can, is you know, I don't even know if it's possible, but you know, y'all may need to take some time with the understanding that the only thing, and I think Mr. Evans alluded to this a minute ago, is that what we're going to do, someone's potentially going to make a motion that there's reasonable grounds to believe that a violation of the act has been committed, and then it gets turned over. Whether it's one issue or the other, it's just going to be a motion of whether the act was violated, or whether there's reasonable grounds that it's violated. And if y'all can, if you're only being actually fined for an issue there's no dispute over, my suggestion is to go outside and try to get this worked out if you can.
Well, that's what we submitted weeks ago, and we're told that we couldn't resolve it that way.
I'm afraid what was submitted was dismiss your case and I'll pay a late fee. I can't dismiss the case just so she can pay a late fee unless that's what the commission would like.
Right, it would be in the form of a consent order. Is
Yeah,
what
and we agreed to that. We
Well,
said we would pay the
again,
late filing fees and the.
If there's some misunderstanding, again, I don't know procedurally what I would need to do at this point, but
Because we were being.
if we could-
Yeah, well, I mean, just to keep, we gotta keep moving down the agenda. So the question now is whether you guys, Ms. Johnson, you're willing to talk with Mr. Lane.
Yeah, well, I mean, I'll.
Okay, and Mr. Lane, and we're gonna go to Ms. Edflo next. Is that your
That's
case,
mine.
or is that, okay? So we're gonna go to Ms. Edflo, and then once, and then who has Mr. Chalmers' case?
I do.
Okay, we'll knock out those three, and then you guys can go talk. And then I'm gonna move to table the matter of Ms. Johnson until the rest of the preliminary hearings are resolved to give them an opportunity to discuss, if I can get a second.
Second.
All in favor, say aye.
Aye.
All opposed, motion carries. So we'll move to Ms. Ladpo, Mr. Lane, whenever you're ready.
Yeah, whatever
Yeah.
is more convenient for y'all.
Ms. Johnson, yeah, so you'll stay whenever he's done, and give Ms. Ladpo an opportunity to come on.
Chair Evans, just wanted to let you know that Mr. Chalmers will be staying for the whole meeting. So if we don't hear his matters immediately, he's fine with that.
Okay, thank you, Ms. Russell. Thank you, Mr. Chalmers.
Commissioners, you have before you case number 2018-0065 TC. This is a commission-initiated investigation that occurred after an audit of Ms. Ladapo's, campaign disclosures. Ms. Ladapo ran for the City Council, District 11, I believe, for the City Council of the City of Atlanta. She most recently ran in the general election of 2017, and unfortunately, she was unsuccessful. During her campaign, the majority of Ms. Ladapo's reports were timely filed, they were complete, they were accurate. The one issue she did have is that she had two filings that were late. She filed late her June 30th, 2017 campaign contribution disclosure report, but it was otherwise complete, as well as she late filed her September 30th, 2017 campaign contribution disclosure report. And on this one, we initially noticed it as late, but in recalculating the dates, I discovered that Ms. Ladapo filed her report within the grace period. There's a 5-day grace period after the due date. The grace period for Ms. Ladapo on the September report ended October 6, 2017, and she was able to get it filed at 11:58 p.m. So she just made
Well done.
Yeah, that's good. I'm glad our server worked, because sometimes a lot of people wait till the last half hour, and it doesn't always allow them to do it on time. So, Commissioners, respectfully, although the complaint says there are 2 late filings, I submit to you there are only reasonable grounds to believe that there's 1 late filing, and that's related to the June 30th, 2017 CCDR, which was due on June 30th but not filed until July 10th. So that's a violation of 21.550 subsection A, or no, excuse me, 21.534 subsection C2A. So I believe there are reasonable grounds to believe, and I submit that accordingly.
Okay. Is Ladapo, is that the right way to say your last name now? Thank you. All right, Ms. Ladapo, go ahead.
Well, the only reason why, I didn't realize I was late, because normally you get a notice from the clerk's office that they are due, and I believe that we didn't get that this time because I think she left. But as far as I knew, I was closing out my account, so I didn't really realize that I had to submit another final, report. I did talk with the clerk yesterday, and she told me to just go ahead and file the closeout so I was not going to be running again. And there was kind of a misunderstanding. I didn't know that I had to do a closeout report. So I think that's, you know, not to make an excuse, I tried to get them in on time, but I think I was so confused about this particular report.
Well, thankfully, there was no issue with the final report and termination statement. I do know that local filing clerks, that being city clerks and county election superintendents in the past, would send out late fee notices. They have since stopped that. It created too much confusion. And as the commission knows, only the commission is responsible for the collection of late fees and the enforcement of the act. Local election superintendents and municipal clerks are literally just filing officers. They take documents and hand them off to us. As far as notices of the late fee, Ms. Latipo received notice from our office on January 3rd, 2018, and again on August 2nd of 2018. It's Exhibit 5 and Exhibit 6 to the complaint contained within your packet. So she did give prior notice of these outstanding late fees, but unfortunately, there was an error contained within one of them. It said she was late on one filing, and she actually was within days. But she did receive notice of outstanding late fees before we proceeded with the suit.
And Ms. Latipo, do you contest that you filed it late?
No, I don't.
Okay, so you admit you filed it late, but you didn't know. Good. Okay. And what's the fee, Mr.
It would
Lane?
be a $100 civil penalty plus a $125 late fee.
And is there a resolution either of you are jointly proposing?
I'm fine with that resolution if Ms. Latipo is amenable to it. That's the
I mean, I'd like to have it reduced if that's possible, but I mean, I'll pay whatever I'm required to pay.
What's your thought about the reduction, Mr. Lane?
That tends to be the commission's standard lowest offer is the $100 civil penalty and the $125 late fee.
And which of those do we have flexibility on?
You have flexibility on both.
Okay.
Any other questions? So it seems as though the issue before the commission is whether you guys want to try to resolve it, and Ms. Latipo says she does. And so then it is a determination for the commission to give what the fee would be. Ms. Latipo, do you have a proposal as far as what fee you think would be fair, other than $225?
Well, I think the $125 to me would be sufficient instead of the $100 additional penalty. Because I did turn all the rest of them in on time, you know, and I think the misunderstanding may cost me, but I'm willing to pay something.
Okay, and the issue before the commission is we can't give reductions every time because that undermines the significance and importance of the rules. So if we give you a reduction and then everyone that comes before us says, I want a reduction too, we have to have a real reason for why we would give the reduction.
Well, I think when you're timely, 98% of the time, I think that one period of time, I think it would be warranted. I just think it would.
And commissioners, I don't mean to overstep my place, and I respect Ms. Latipo's position. The one issue that we have here is that Ms. Latipo received 2 notices from our office by certified mail letting her know that she had a late fee. As long as she paid the late fee, nothing else would occur. That is a common practice for us since we are charged with the collection of late fees. That is one issue that the Department of Audits and Accounts back in 2014 found that our commission greatly found on, was collecting these outstanding late fees that were very substantial. Ms. Latipo, of course, at $125 is not a substantial account, but she is one of many where people receive these notices and they chuck them in the trash, which then leads us to, or they ignore it or what have you. And then we're required to basically file a complaint. We've audited their account. We've had to expend man hours, time, and resources to collect this $125. So the $100 is kind of a slap on the wrist of next time you get a notice from us or the second notice, it's time to pay, and there's a little bit of punishment to go on top of that, simply because you had at least 3 bites of the apple, because when people file late, they're given a notice that they filed late. And then they've received at least 2 more notices from our office over the course of several months. And they're still
And Ms. Latipo, do you recall receiving those?
I recall receiving one notice, and what we did was we were trying to get all of the documents in. I did not know the notice was that, I thought the notice was you're late, you need to get your report in, and that's what we did. you know, we got the report in. So, I mean, I didn't think that it was a notice to say, either get it in or we're going to fine you. I mean, I thought it was, you get it in or we're going to fine you. I got it in, so I didn't think that it was going to be an additional fine. I mean, the notice to me was a great, because there were a lot of things going on in my life too at that particular time. And so I may have, delayed in doing the report, but we did get it in, so I mean, it wasn't like we were trying to dismiss the fact that we had to do it, because we didn't dismiss the fact that we had to get any of them in. We took it very seriously, and we got them in on time. So this one time that we didn't get it in, it seems to be more abusive than anything else.
Mr. Lane?
Yes, sir.
What's the time period that we usually allow folks to pay their fines and late fees?
When you're
Or
doing.
penalty and the late fee, the $225 in this instance.
You mean like, is it like a payment plan?
Well, yeah, but I mean,
The-
yeah, right, that's pretty much right. What does it do? I mean,
Sorry, I was just thinking like the late fee part, but no.
Yeah.
If the standard that the commission offers is 30 days.
okay,
We have been known to increase it to 90 days for fines of like $225.
okay.
To get into year-long payments or 2-year-long payments, they have to be substantial.
Sure, I understand.
But in fact, I think you may have one coming before you today with like a 60-day period for $125, if I remember correctly. So it's not uncommon for there to be a larger period of time. I don't know if I'm answering your question.
You have, because it's up to you all to decide when you have to work it out. And I think, Ms. Latipo, I think you've heard kind of an outline of the procedure here, that if you all can't come to some agreement, then this commission votes on the determination as to whether or not the act has been violated. And then it goes to a full-blown hearing, if I'm correct. And then, then you'll have to spend however many more hours away from whatever else you'd rather be doing than sitting here right now. And so in my view, it's a prime opportunity to reach a compromise. I think Chairman Evans' point is one that you should consider, which is, while we could certainly make an exception here, every time we make an exception, there needs to be some justification, because the next person will ask for an exception as well. It strikes me as though the compromise that I would encourage the parties to consider is, if there's not some reduction of the 225, but maybe a compromise of you get an additional 30 days, I mean, I think that's a win-win. You have to determine that, but,
I just have one question to ask, and that is, when you send these letters out, are you penalizing people because they're late, or are you notifying them that your report needs to be submitted? I mean, if it's a twofold kind of thing where you're saying you're late and this is your fine, or, and regardless of when you turn it in, you're going to have to pay this fine, or does that mean that when you turn it in, you've completed your requirements as far as the law is concerned?
And Ms. Latipo, that's a good question, but we got to keep the agenda rolling. So I would propose, we will move to table it, if you guys want to go talk about it and maybe come to a resolution. If not, we're going to have to move forward on voting on whether probable reasonable cause exists to believe you violated the act. It sounds like that's not even being contested. So the commission really doesn't have much of a choice if you admitted you filed it late. It just really comes down to that fee. And so I would propose, if Ms. Wetzel, you're prepared to go through some of your preliminary hearings, you go forward, and that gives Mr. Lane an opportunity to speak with both Ms. Johnson and Ms. Latipo. Ms. Wetzel, you ready?
I'm ready.
Okay.
we need to motion to table.
Yeah, motion to table.
Second.
Just again, this is not tabling it for the meeting, it's just temporarily until they have an opportunity to speak.
That's right. And all in favor, say aye.
Aye.
All opposed? Hearing none, motion carries. Thank you, Ms. Latipo, for coming.
All right, commissioners, hello.
I will first start with number 5, letter G, 2018-0046, in the matter of Elizabeth Clark Price. That is now a consent order. Would you like to go ahead and consider that consent order, or would you like to move it to the consent order portion of the agenda?
I would move it to the consent order.
Okay, so we will move along to letter H, case number 2018-0022 PC, in the matter of Carl Scott Evans. Mr. Evans was a candidate for the Forest Park City Council in 2017. He, as a candidate for elected office, he is required to file several reports, namely being a campaign contribution disclosure report or a personal financial disclosure statement. He failed to file a September 30th, 2017 election year CCDR, an October 25th, 2017 election year CCDR, and a December 31st, 2017 election year CCDR. He did not file those. I believe he stated in his response that he had some misunderstanding and some confusion with what the clerk told him. However, he did not file them, and he still has not filed them. A notice of late fees was sent to him. The statutory period for him to be able to pay those elapsed, and this matter was referred to me for collection, and this is how we are here today. I've spoken to Mr. Evans. He has sent in a response, and then he supplemented his response Monday of this week with information that he is on Social Security disability, does not have an income. And what I'm asking the commission to is to find that there are reasonable grounds to believe that he violated OCGA 21-5-34 3 times when he failed to file these campaign contribution disclosure reports. But with the aside that we have 30 days before these are forwarded to the Attorney General's office, and I believe that Mr. Evans and I can come to a resolution to somehow deal with his income issues, because he does have a very minimal income, and $375 in late fees would be an extreme burden, and in addition to a civil penalty. So I would ask that we go ahead and forward the matter to the Attorney General's office if you find that there are reasonable grounds to believe that the violation occurred, but with the knowledge that we will be working diligently to try to have a compliance order, consent order to you in March, if that's what our next occurrence.
Was Mr. Evans informed that he was on the agenda today?
Yes, he was. He chose not to appear.
Okay. The commissioners have any questions? Good.
I've moved that we find reasonable grounds to believe that the act has been violated.
And I'll second that. And hearing the motion, do we have any discussion? Hearing the motion, the second, I'll call the question. All in favor, say aye.
Aye.
All opposed, say nay. Hearing none, the motion carries. All right, Ms. Wetzel, proceed.
We are now at letter I, matter, case number 2018-0020 PC, in the matter, of Jason Estevez. This is also, we have reached a consent order, and he emailed it to me this morning, and we can move that to the consent order portion of the agenda. And that means we are moving on to letter J, case number 2018-0018, in the matter of Christopher Brown. Mr. Brown was a candidate for the Atlanta City Council during the 2017 election. As a candidate, he was required by OCGA 21-5-34 to file campaign contribution disclosure reports. He filed all but one report. However, 2 of the reports were late. So that is 3 violations of OCGA 21-5-34C. He has not paid any of the associated late fees. He's been given notice. He was given a notice of his late fees. The statutory period elapsed. It was forwarded to us for collections, and he has been notified of this meeting and has failed to appear. So I'm asking that the commission would find that there are reasonable grounds to believe that the respondent violated the act.
Okay. Commissioners have any questions? Okay. I will move to find that reasonable grounds exist that the Campaign Finance Act was violated.
And again, hopefully a notice from the Attorney General's office will make them take this matter more seriously.
Hold on, we got to vote.
Oh, sorry. Sorry.
I'll second that.
Okay. I'll call the question. All in favor, say aye.
Aye.
All opposed, say nay. Hearing none, the motion carries. Go ahead, Ms. Wenzel.
All right, we're now at letter K of case number 2018-0062, PC in the matter of Jareen Grimes. Ms. Grimes was a candidate for the Marietta Board of Education. As a candidate for elected public officer, she is required to file campaign contribution disclosure reports in accordance with OCGA section 21-5-34C. And she is also required to file a personal financial disclosure statement in accordance with OCGA section 21-5-50. She had previously run for this office in 2013. And during the audit, after we were notified of her 2017 late fee, it was noticed that she had not timely filed a personal financial disclosure statement in that first candidacy. And then we were notified by the local filing officer that she failed to timely file a December 31st, 2017 campaign contribution disclosure report. And she was given notice of the late fees, she was given notice of the meeting and of the complaint, and I have not heard from her, and she has failed to appear. I would ask that the commission find that there are reasonable grounds to believe that she has violated the act.
And so she was given notice that she was on the agenda today?
Correct.
She chose not to come?
Correct.
Did she choose not to come? You just didn't hear from her?
I didn't hear from her,
Okay.
but she was sent a certified notice and received it.
Okay.
Okay. Any other questions from the commission?
Ms. Wetzel,
Yes, sir.
there's alleged violations for both the 13 run and the 17?
Correct.
Okay.
And they both are within this statute of limitations.
Okay, good.
This is not one where there was an open case previously based on the 2013 run?
Correct, no sir. This is just a case that was opened in this year of 2018 based upon our attempts to collect the late fee through noticing and because that she failed to pay the late fee, it's escalated to a collections matter, which we file a complaint, and then the matter, ultimately, if there's no resolution prior to that, it comes before you.
So was the commission aware of the 13 violation when it learned of the 17 violation?
Correct. So what I believe happened, what our auditor, in her findings, first a notice came from the Marietta Board of Elections, and it said she failed to file this 2017 report. In 2013, 5 local filers were actually required to file with the commission. And so when the auditor goes and audits these late fee cases, we want to send out one late fee notice because they have to be sent certified to save resources. And also we want to try to collect whatever we can in one fell swoop because that is part of our duty within the act. So she did an audit and she goes back as far as she can. She'll inactivate any fees that fall outside the statute of limitations. And these were the 2 that fell within that were still viable claims.
Understood.
Commissioners have any other questions? Go ahead.
Then, Mr. Chairman, I move that we find that there's been a violation of the act and proceed accordingly.
I'll second that. And I'll call the question.
I'm sorry.
Go ahead.
Just to clarify, the reasonable grounds exist that the act has been violated. I just want to
Yes.
make it to amend
There
the
you go.
motion.
It's strange terminology.
Okay, well, right, then I'll amend the motion and move that we find that reasonable grounds exist to believe that the act has been violated and that we proceed accordingly.
And I'll second that amended motion. Any discussion? Hearing none, I'll call the question. All in favor say aye.
Aye.
All opposed say nay. Hearing none, the motion carries.
Commissioners, we're now at letter E, case number 2018-0066PC in the matter of Corey Ruth. Mr. Ruth was a candidate for the Atlanta City Council during the 2017 election. As a candidate, he's required to file campaign contribution. Go ahead.
Yeah, I've got it as Raina Johnson.
It's L. Did I say it? I apologize.
It's okay.
Sorry. Okay, we are now at matter L. Thank you. Case number 2018-0066BC in the matter of Corey Ruth. Mr. Ruth was a candidate for Atlanta City Council during the 2017 election. As a candidate, he's required to file campaign contribution disclosure reports in accordance with the election year filing schedule found at OCGA Section 21-5-34C. He failed to file the October 25th, 2017 report and the December 31st, 2017 report. My suspicion is that he lost the election and figured that he didn't have to file anything to close out his account. However, unsuccessful candidates are required to file at the same time as successful candidates are until the election cycle is finished. Mr. Ruth did contact the commission. I tried to contact him, return his call, and so did my paralegal several times. We are unable to reach him. He knew that his matter was on the agenda, but he has not appeared. I don't know if he just chose not to appear, but we have not been able to
How do we
speak
know
with
that he knew he was on the agenda?
because he received a note of meeting notice, a certified mail of the meeting notice. That's how we send our meeting notices out, and we track that by their return receipts, their green cards.
Has the commission attempted to call him?
Yeah, we've called him multiple times, and we've returned. He called us first, and we returned his calls, and we have not been able to reach him at all. So this is where we are at the moment. I would ask that the commission find that there are reasonable grounds to believe that he has violated the act by failing to file these last two reports. And hopefully in between the 30-day period, knowing that we can say, have the force behind saying, this is going to go to the Attorney General's office, and hopefully that has more weight than us just sending a notice that they will have a resolution and we can have this case back before you for a consent order at the first quarter meeting.
Okay, thank you.
That's
Ms.
the
Russell.
intention for all of these.
Commissioners have any questions? Hearing none, I'll move to find that reasonable grounds exist to believe the Georgia Transparency and Campaign Finance has been violated. Do I hear a second?
Seconded.
Any discussion? Hearing none, I'll call the question. All in favor say aye. Aye. All opposed say nay. Hearing none, the motion carries.
We are now at letter M, 2017-0212 PC in the matter of Erica Woodford. This matter actually came before the commission at the September meeting to approve a consent order. In between the time that we were sent the consent order, we were sent the consent order after the meeting. We received that after the meeting. However, if you will look in your binders at the consent order that we received, and I just want to bring this to your attention because it really is not a preliminary hearing, but there are some issues. If you turn to the signature page of the consent order, the attorney signed on behalf of the respondent, which of course, according to Georgia law, an attorney is allowed to bind their client. However, he just marked it, and I want to bring that to your attention for y'all to determine whether that is sufficient or not, because that just was odd in my opinion.
Have we attempted to call the attorney to voice concerns?
Yes, and he responded back with the code sections about that an attorney can bind their client, and that was it. And I have an email from yesterday, and it's in the binder, the email that he responded.
So what's your concerns?
My concern is that he just put an X.
Well, I think that it doesn't matter. I mean,
Okay, and also wanted to bring that to your attention too, when you're going to sign the agreement that.
I want to dig a little more on that.
I
do too. Yeah. And I haven't had a chance to look at the email, but.
The email,
No, go ahead.
the email addresses only the fact that, he cites 1519.5 where he says that an attorney is authorized to sign a consent order on behalf of a client.
Right, and he also removed the signature line for the client too. When we sent the original consent order to him, it had a signature line for the client, which is common practice, what we do. And I don't disagree with him about the law about binding. However, I'm concerned that his mark.
I do, and listen,
I mean, right, I just wanted to bring that to your attention.
Contract law, I mean, if you, the image of the mark doesn't matter as long as you have intent to make the mark and be bound by the terms of the contract. My bigger concern is the fact that an attorney is doing it.
Right.
Yeah. And deleting the client and then it's so forceful, that's my concern, because the client has to be willing to agree to the terms of the consent order.
And that's my fear. So I can go back and just, you know, I also I want to respect attorney-client privilege and don't want to contact the client without, but I feel like maybe this might be an occasion where I may need to ask if she's still represented by him, but I just wanted to bring this to your attention.
Yeah, I don't know. I mean, if he didn't have the authority to sign it, then, you know, that's going to be his problem.
Right, so we just accept it but I also just wanted to, when
If the
he
commission's
signs this.
satisfied with the mark as opposed to a signature, then I'm not sure that we don't accept it. And if there's a problem with whether, I mean, he's clearly got apparent authority.
Mhm.
I mean, as long as we've got notice that he's represented.
Correct, we have.
Yeah.
And I think that's all we can do.
Okay.
I agree, between the mark and the email.
Right.
I think that, yeah, we don't think we have an issue with the mark, but if it turns out in this matter that, you know, with the consent, the fees are not paid, you know, that's potentially an issue for us to refer to the state bar.
Correct.
But that's not, we can't presume anything right now, so I think we have to accept it.
Okay, I wanted to make you aware of the situation,
Thank you.
and that is my last item for preliminary hearings. I'm
Ms.
prepared.
Russell, let me add one
Oh, I'm
thing.
sorry.
If the consent order is not followed, we would like to be made aware of that, because if
I
there's an
will.
issue that needs to be reported by the agency to the state bar, we should.
Okay, most definitely, I will keep you abreast of the situation, because I also am interested as well.
And so that has been moved to the consent orders.
Well, it's already been approved, it's actually already been approved. We just didn't have a signed in hand. I told him that we would present it with the knowledge that he would send it in, with the agreement that he would send it in within a short period of time. However, he waited 3 months. So it has already been approved. It was approved at the last meeting, but I just
So no action from.
So
the
no action
commission.
required, no,
Okay.
sir.
And is that all of your preliminary?
Correct.
Okay, thank you. Mr. Lane, are you prepared? Any developments with Ms. Johnson, Ms. Latipo?
Yes, Mr. Chairman, we have developments. If you'd like, Ms. Johnson can go first.
Ms. Johnson, are you ready?
Yes.
I entrusted Ms. Johnson with the consent order, so I'm going to mix it up with Ms. Latos. She was kind enough to keep it for me. I think the confusion that Ms. Johnson and I had as far as the amount of fine being proposed is when you read our consent orders, we detail what the violations are with the corresponding fine, but then the payment part of the order, some people will add them together, so they're doubling or tripling their fine. So I think that's where the confusion was. After speaking to Ms. Johnson, we've come to an agreement for the payment of a $275 fine, that's a $150 civil penalty, and the $125 late filing fee due and payable within 30 days from the date of this order. The only other thing for the commissioners' consideration is normally when we have an unrepresented party, our consent orders have a notary public section. Since Ms. Johnson's here, and I recognize Ms. Johnson from her campaign flyers.
And we are on the record.
May we dispense with that formality and just allow her to execute and move forward?
We do have a notary here.
Yeah, I have a notary.
Then that will solve that.
Let's put on the suspenders the whole thing.
Well, good, congratulations.
So that'll be moved to consent order also?
That's right.
Okay.
And that is the resolution for Ms. Johnson.
Well, thank you to both of you.
Sorry. I think that was a very good outcome. Again, we appreciate the fact that you come and you bring these things to our attention. And sometimes, you know, when you come and we're able to kind of talk things through and explain the process from our perspective, you know, we reached the type of conclusion that we did here today. So
I
And,
would suggest you all just allow people to pay $125 on the website for a late filing fee to be done with it.
Mhm. Sure, well, that's something to consider. And just, I will go ahead and move to adopt that consent order, if I can get a second.
Second.
Any discussion? Hearing none, I'll call the question. All in favor, say aye.
Aye.
All opposed, say nay. Motion carries. Thank you. You're good to go, Ms. Johnson.
Thanks, Johnson.
And then for Ms. Latipo, we've reached a resolution as well, sir.
Okay, good.
In speaking with Ms. Latipo, unfortunately, I don't have a consent order here for her to execute. But we have agreed upon the payment of $125 civil, or $125 late fee, $100 civil penalty to be paid to the commission within 90 days from today's date. Of course, I will get Ms. Latipo the consent order for execution, and we'll get it to the chair if that's the adoption of the commission.
And what would be the timing on that? Today, or would we need to table this to the next meeting, hoping it gets moved to consent order for the next meeting?
You can adopt the consent order today, and then I'll simply reduce it to writing. Or we can table it, whatever your preference.
Does the commissioners have any thoughts on it?
I'd rather just adopt the consent order today and reduce it to writing, and hereby move that we proceed along those grounds.
Okay. So the terms of the consent order are,
It's a $100 civil penalty for one violation of section 21534C2A, that's the June CCDR being filed late. And it's a $125 late fee, also for the same filing. The order will also denote within the holding that the allegations related to the September late filing are not applicable because she filed within the grace period. There was no violation as to September. There was just one violation, not two. And we will detail that the second one is dismissed for all intents and purposes.
and Ms. Latipo, are you okay with those terms? Is that correct?
Yes, I am, but he is also going to provide for me evidence that they sent the notice, because the notice that I have was not the notice that he was talking about.
The two notices of late fees were sent to the same address Ms. Latipo received her suit at, and they were all served by certified U.S. mail. I did not bring her full case file today, but when I send her the consent order, I will also attach the USPS delivery confirmation that we received.
So, again, is that sort of an outstanding issue then? I mean, is there still some possibility that if you don't agree with that notice that he sends, that you're not going to sign the consent order?
Well,
I mean, if so, then I'm thinking that we need to move.
I think that the chair brought up the fact that it's a foregone conclusion that I'm guilty because I did receive the notices, and I said I did.
I think maybe
But
he's got it.
I did not, I'm not sure that, when he showed it to me, I had not seen that before. Just for my record, I need to know.
Well, I think Ms. Latipo, what we're trying to figure out in terms of how we move forward, procedurally speaking, is if you all have reached an agreement on payment of the $225 fine and penalty, and you're going to do that in 90 days, then that's something that we can move to approve. If you have concerns about receipt of the notices, and your concerns about receipt of the notices, and the commission's need to prove that those were sent are a condition of you signing the consent order, then that's something we need to know. Do you understand what I'm saying?
Right, and well, I guess my concern is that if that receipt of those notices is a caveat to whether or not I'm guilty or innocent, then I think that the notices are very important. Because what the chair said, that you agreed that you received the notices, and he said that I ignored the notice, but if I didn't get the notice, that's an issue that I think the body should know.
I'm going to see if I can kind of put a fine point on it. I haven't heard you say today that you are not in violation of the act. The question is whether or not you received notice that you're in violation of the act. What we're proceeding along is the grounds that, or the understanding that you acknowledge that you're in violation of the act, and we're trying to bring some resolution to that. And we can do that today based upon the agreement that I think you all have reached. If you're conditioning your agreement to the consent order upon some form of proof that you received the notice, then there's no agreement, and you guys will have to work that out. So tell me where we are from your perspective.
Well, I agree, if my case is based on the fact that I received notice and I ignored it and did not follow through on completing what I was required to do, then I accept the fact that I did not do it, but I cannot agree with it that I was giving notice and that I ignored it, and therefore I should be fined, because what he's saying is there are two penalties. There's one for not filing, and then there's one for failing to file. And so,
Well, out of fairness to you, Ms. Latipo, I would recommend that we continue it, just so everyone fully is aware. We don't want to put you on the spot and make you agree to something you're not comfortable with, because that's not what we're trying to do. We're trying to just put this and enable you to move forward and resolve it, but I don't want there to be any misunderstanding and you feel as though you were hurried. So I would move to continue this to the next meeting under the hopes that a consent agreement is reached between now and then. Go ahead, Mr. Lane, if you have concerns.
Just one thing for the commission to consider. Within the code, once the commission finds reasonable grounds to believe, the cases are automatically stayed for a period of 30 days prior to any referral to OSA or the Department of Law that allows staff to continue negotiating a resolution to the case. If that's something you want to consider so you don't have a revisit of a preliminary hearing, it would allow us to, or allow me to address Ms. Latipo's concern, continue to negotiate that consent order, since we now have a contingent portion to it. And if we are unable to make that resolution, then the case would be referred to the Attorney General's office, because you've already found reasonable grounds. Because I'm not hearing a denial that there's no reasonable grounds. What I'm hearing is a dispute now as to the terms of a proposed resolution. We can still negotiate that resolution after a finding of reasonable grounds. That's just one of the many tools you have in your arsenal, so we're not coming back here on a preliminary hearing again for the commission. Because I don't think the facts are going to change at that next hearing. It's either going to be, we agree to the consent order, that contingent that she either did or did not receive the notice those 2 times for the late fee notice, or she didn't.
From what I'm hearing, we've got 2 unseconded motions right now. We have one motion to go ahead and approve the verbal consent order, and we have a motion to continue.
I'll make it easy. I'll withdraw my motion.
And so now we have discussion on the motion to continue.
Right, and I think that Mr. Lane's point is well taken, and we've done that on a number of occasions already with Ms. Wetzel's cases, where we have found reasonable grounds to believe that violations of the act have occurred, in hopes that with that finding, it will create some push behind the parties to get the matter resolved. And so, in an effort, I don't want to muck things up or anything like that, but I'm actually going to make another motion, which is a motion to find that reasonable grounds exist to believe the violations of the act occurred here, since this is a preliminary hearing still.
Any discussion?
It sounds to me like the issue.
I think it needs to be seconded first.
Yeah.
Because I think it dies for lack of a second if it's not seconded.
That's true.
Did you want a second, Commissioner?
No, all right. But my thought is, I don't want to put too much pressure on you, but it does need to get resolved. Yeah, and that, I would prefer for it to get tabled. It sounds like you guys are close to a discussion, a resolution, and I want to encourage you to do that. I do, my position is I want you to take note that the commission is, if they elect not to find reasonable grounds, they're doing that in order to help expedite the resolution and not hold your back to the wall. But that's my position. I'm only one amongst 4 commissioners.
well, it indicates to me that notice is not required. So if it's not required, then it should not be considered as to whether I received it or not. Then we're back at where we started, and we, there's no reason not to negotiate.
I second the chairman's motion to continue the matter to our next meeting.
Okay. So any discussion? Okay, I'll call the motion, the question the motion to question. All in favor say aye.
Aye.
All opposed say nay.
Nay.
Hearing 3-1, the motion carries and it will be tabled to the next meeting. I encourage both of you guys to continue discussions to resolve it. Thank you for coming in. We really do appreciate it.
Thank you.
All right, Mr. Lane, are you prepared to proceed for the rest of the matters that you have?
I believe so.
So whenever you're ready.
All right, I'm assuming we're starting at letter A with Ms. Barnes Sutton. Would that be
That's
fair?
perfect.
I think I can start with an easy one. Ms. Barnes Sutton's commissioners is 2015-0050 PC. That case is being removed. A subpoena was served recently for Ms. Sutton's bank records. A defense Ms. Sutton raised at the last minute necessitates that course of action. So unfortunately, we weren't prepared to go forward. She is represented by an attorney, Mr. Otis Williams. Mr. Williams is aware of the new subpoena, and he's aware of the continuance of the case from today's calendar. As he said, he was glad to have his evening free. So he has received notice of that, and that's one reason why he's not here today.
Okay.
So that is Ms. Sutton. I believe next is Mr. Lockhart, which is letter C. Commissioners, before you have case number 2018-0021 PC, in the matter of Mr. David Lockhart. Mr. Lockhart served as the mayor of Forest Park from 2013 until 2017, when he was unsuccessful in the 2017 general election. This is a commission-initiated case that was done after a number of late filings were reported to us by the local election superintendent, or actually the municipal clerk, in Forest Park. After Mr. Lockhart's loss in 2017, he stopped filing his required campaign contribution disclosure reports, as the commission is most likely aware, under section 21.534. When a candidate loses their election, they have to continue filing all of the required reports in that calendar year as if they had won the election. So he owed, after he lost his primary challenge in May, he owed a June, a September, an October, and a December CCDR. He filed June, but he failed to file the September 30th, October 25th, and December 31st, 2017 CCDR in violation of 21.534 C2A. We've reached out to Mr. Lockhart at a number of his addresses. He has a firm located in Forest Park. He also has one located, I believe, in Walker County. We've also served him at his personal residence located in Forest Park. We've had no correspondence from him, no answer has been filed, and no responses to any of our attempts to reach out to him have been forthcoming. Based on what we have, since there just simply are no filings, I would submit to the commission that there are reasonable grounds to believe that a violation of the Campaign Finance Act has occurred at least 3 times by the failure to file 3 campaign contribution disclosure reports.
Okay. And did he receive notice that he was on the agenda today?
Yes, sir.
And did he respond?
No, sir.
Any commissioners have any questions?
You said Mr. Lockhart, Mr. Lockhart, member of the bar?
He is a member of the bar. And we used his bar registered address as well as the address contained on his 2 websites. He has one website for Forest Park and one for Walker County. And they both look active. They've at least been updated recently, so I'm assuming they're active. But at least his bar address has been used. And we did get personal service at his Forest Park residence. That has not changed.
Okay. Any other questions? I'll move that reasonable grounds exist to believe there's been a violation of the Georgia Transparency and Campaign Finance Act. Do I hear a second?
Second.
I'll call the question. Or any discussion? Hearing none, I'll call the question. All in favor say aye.
Aye.
All opposed say nay. Motion carries.
Next, commissioners, you have Mr. Raynard Johnson, which is case number 2018-0025 PC. This is also a commission-initiated case. Mr. Johnson was running, or was a member of the Board of Education for the City of Atlanta. He was a member from 2013 through 2017, and he was unfortunately unsuccessful. In the review of Mr. Johnson's campaign filings, the commission officers identified that Mr. Johnson failed to file a great number of his campaign disclosures. He failed to file a December 31st, 2013 campaign contribution disclosure report, and that was from his election year, so that's a violation of 21.534 C2A. He late filed a March and June 2017 CCDR. That's also his election year, so it's a violation again of 21.534 C2A. And then he failed to file his September, October, and December 2017 CCDR, so that's again 21.534 C2A, the election year schedule. And then there's a little quirk, is he was in a runoff, which means he had one more report that he had to file, the Killian reports, where he needed to file before the runoff election, which would have been due on November 28, 2017. That one was also not filed. He was provided notice of these various late fees, has been served with a complaint at his address or his residence. We've had no response from him, no answer. Our attempts to reach out to him have gone unanswered. So I would just...
Have you, is there any indication that he's moved?
No, there is not. Unfortunately, this is not an uncommon occurrence when you have unsuccessful candidates who have, he has a substantial late fee balance. They receive notices from us and they're ignored. I wish it were an uncommon occurrence, but.
All right, any questions from the commissioners? Hearing none, I will move that reasonable grounds exist to believe that the Georgia Transparency and Campaign Finance has been violated. Do I have a second?
Second.
Any discussion? Hearing none, I'll call the question. All in favor, say aye. Aye. All opposed, say nay. Motion carries.
I believe that's all of the preliminary hearings I have, Mr. Chairman.
Great.
And we'll move to the consent orders if you're prepared for that.
I will propose that we take a 5-minute recess, and then we'll jump into the consent orders. Do I have a second for that? Second. Second. All in favor? Aye. I'll move to reinitiate the meeting. Do I hear a second?
Second.
Any discussion? Hearing none, I call the question. All in favor, say aye.
Aye.
All opposed? Motion carries. I will propose, and we're going to have some questions on this too briefly, but I will propose that we adopt the consent orders en masse. Do either of you guys have any opinion or preference on that?
No problem.
That works for us, Chair.
Can I just ask the last?
Go ahead.
Mr. Chalmers, I know that you have at least one consent order. Yes, two. Is there anything, if we're going to do this, en masse, where we approve these en masse, is there anything that you want to comment upon with regard to your two?
No, sir, assuming it goes the way I expect, I don't have anything to say.
I just want to make sure.
Thank you for asking.
Okay. And so for each of these, and so how many do we have total here?
1, 2, 3, 4, 5,
10, I believe.
And then 11, 12.
So 12 moved.
Wait,
You would have the 10 that are currently on there.
Correct.
Then one for Mr. Chalmers for me, and I move on for Ms.
I have
West.
two. I have two that moved. I have Jason Estevez and Betty Elizabeth Clark Price that moved.
Okay. And do we know if any of these people want to make a statement, or any of them present today?
Just Mr. Chalmers.
Okay, so no statement. And so each of these individuals are aware of the consent orders, right?
Correct,
And they've consented to it.
correct.
Yes, sir.
Do we have any concern about signatures?
No concern about signatures. Sorry.
Or marks.
There is one case though that you may want some details on it. That's James Marcus Cantrell.
Okay, well, let's hold it. We'll keep that one. Is there any other ones that we may need to hear individually? Okay. The commissioners have any other questions?
My only suggestion is for you guys to go ahead and read the case numbers and the names of the individuals or entities into the record, just so that we know exactly which ones were.
Yeah, and so what I would propose is, except for the one you just mentioned, read the remaining ones, and the case numbers, just like Mr. Cranville said.
Commissioners, the consent orders that you'll be considering tonight are in the matter of Benjamin Watson, 2018-0105. After that, you have case number 2017-0211 PC in the matter of Charles K. Shaheen. And then you have 2014-0069 in the matter of Mike Boudreau. And then you have 2018-0063 PC in the matter of Ms. Sandra Sinholm. And then you have 2017-0117 PC in the matter of Mr. Kenton Wainwright. Kenton, Kenton.
And Commissioners, the consent orders that you will be considering that I have for you today are in the matter of One Forsyth Action Incorporated, case number 2018-0050. The next is in the matter of Jerry Wood, case number 2018-0040. The next is in the matter of Gerald E. Green, case number 2018-118. The next is in the matter of Jason Estevez, case number 2018-0020 PC. The next is in the matter of Elizabeth Clark Price, 2018-0046. And the final is in the matter of Lowell Lay Ralph, case number 2012-0038.
Okay, and just to clarify for the record, for each of the case numbers that you all just referred to, each of them are aware of the consent order.
Correct.
They've signed the consent order,
Correct.
and we have no concern about authority issues on whether they. Is that correct? Okay. With that, I will move that the commission adopt each of the mentioned case numbers en masse. Do I have a second?
One second.
Any discussion? Hearing none, I'll call the question. All in favor say aye. Aye. All opposed say nay. Hearing none, the motion carries. And I believe, Mr. Lane, there was one consent order you wanted to reference individually.
Yes, sir. And it's just simply to update the commission on to why it came back before you. It is the matter of James Marcus Mark Cantrell, case number 2015-0056 PC. That case came before the commission last meeting in September for a consent order which was adopted and approved. Unfortunately, Mr. Cantrell executed a prior order that was sent to him that did not reflect the terms that you adopted at your September meeting. We had gone back and forth, and unfortunately, he didn't print out the last one I sent him. He signed a prior one. So the actual order executed by Mr. Cathy had a much higher fine than what he ultimately agreed to. We discovered that error, so I'm just bringing back to you this consent order, which reflects the terms that you agreed to in September. So that's to perfect the record. Because unfortunately, the signed order we have isn't correct.
So does it actually need to be approved again?
I don't necessarily think so, but it has to be re-executed. I just didn't want y'all to think you were trying to slip something past y'all. And full disclosure, I don't necessarily think, because you've already approved the consent order, and you approved it at the September meeting.
We approved the correct one.
Correct. You approved the correct terms. We just executed the wrong document, which does not reflect the terms. So I think you're fine just to re-execute the new correct terms that are written down. I don't think you have to vote to approve again. I just didn't want y'all to be like, why are we hearing this again? Or
What do the commissioners think?
Well, I think it's fine. I think you just have to, I think you just have to sign the correct one. I think it's almost in the nature of a scrivener's error.
it is.
Okay. So that's all. So consent orders are done. Next on the agenda is consideration of adjustments to maximum contribution limits. Did either of you all handle that, or is that Mr. Rhodes?
We can present it, or or we can hold it. I did the calculations, so, or it's your preference, really. He was going to present it.
Are there, we'll wait for Mr. Ritter. Are there any other items on the agenda we can move up for the sake of time?
everything on the agenda besides Christian, the Attorney General's update. If you wanted to do that, and the scheduling of the dates, y'all can go ahead, you can accomplish those.
Okay.
And public comments, which I think Mr. Chalmers is the only member of the public here, and he doesn't have any comments. So those are the so items.
Not public comment.
Yeah, right. So items 10 and 11 you can address now.
Mr. Fuller, are you prepared for the Attorney General update?
Mr. Chair, thank you. I don't have any updates at this time to get to the commission about any litigation.
Okay. So we can move forward with scheduling the dates for the quarterly meetings. And Mr. Lane, or Ms. Wetzel, we appreciate your input on months that are preferable as far as your caseload, and we can then work together between the commissioners to pick some available dates for 2019.
So traditionally, our meetings have been scheduled at the end of March, at the end of June, at the middle of September, and the middle of December. I think Robert and I think that schedule works for us, especially in the new year, because January we will be doing lobbyist registration and renewal, and also it'll be during session. So having a meeting in January is not conducive for us. Really, after session is the best time. Also, because at that time legislators can. They have legislative privilege, so if we have cases against them, we can't necessarily make them appear and put those on the agenda if we do that during session. So, Robert, do you have any? I think March works.
I think March works, and I think the schedule we've been adhering to is functional. It gives us time to prepare cases, work up additional cases, and that way we have something of substance to consider.
Yeah, and I think we should stick with that tradition. So I've got end of March, middle of June, middle of September, middle of December.
Correct. And traditionally, today's an exception, we've been doing them on Thursdays, which is great because that gives a little bit of time for last minute negotiation. However, if there's a better day for y'all, we are open to that.
No, we want to accommodate you guys. You guys are the ones.
I think Thursday works.
They tend to work on, it's something magical about last minute negotiations. People like doing on Wednesday.
Okay.
So we have March 21st or March 28th is.
Okay.
21st. I mean, again, I'm just one person, but I know that day's not going to.
Okay, well, that also gives us an extra week and also maybe session will be over by then.
All right, how about the 28th?
The 28th works for me.
Okay.
Yeah, 28th is fine.
Okay, so we'll do March 28th.
And then we have June 20th or 27th. I know the 27th is right before Memorial. Is that, wait, when is Memorial? Okay, just, that's not Memorial Day, it's in May. I know my holidays, I'm sorry.
Okay, does the commissioners have preference between the June 20th or 27th?
I don't have a preference.
Either one's fine with me.
Yeah, either one is fine.
All right, we'll do June 27th.
Okay, perfect. And then September the 12th, 19th, or 26th.
It's so far in advance, man, I'm clear.
Right?
I've actually got a commitment on the 19th of
Okay,
September. So the 12th and, or what else?
Let's stick with the last Thursday of the,
26th.
and then we can just move up the December to accommodate for Christmas if that suits y'all.
Commissioners, does September 26th work?
That works.
And then I would propose December 12th or 5th. And we don't have to do it on a Thursday, because I understand that December is a tricky month for a lot of people.
I actually have of 19, I actually know that I have a commitment on December 12th, so the 5th.
Well, that's really funny because I actually know that I have something on the 5th.
So we can move to Wednesdays or we can move to Tuesdays.
So the 4th or the 11th are good for me.
They work for me.
The 4th is actually really good because my other commitment is up here in Atlanta.
Okay, well, let's do the 4th then, if that's all right with y'all.
Sorry about that.
No, that's fine.
Let's work with your schedules, that's no problem.
Okay, well, good. Well, we've got, and you guys will send us calendar invitations for that. Also, fantastic.
Could you read those dates to me again?
Yeah, so we got March 28th, June 27th, September 26th, and December 4th.
Correct.
All right, well, we will next go to public comment. Anyone from the public want to make comment? Okay, so we've got the report of the executive secretary, the maximum contribution limits, and then executive session remaining. I guess we can eat lunch now for the time being.
Do you want to do executive session and lunch together? No? Okay.
Now, we're going to wait for Mr. Ritter to return.
Okay.
But I will move that we take a recess for the commissioners to have lunch. Do I hear a second?
Second, and a question, do we need more than half an hour? I don't think so.
It's just a couple.
Yeah, right, I'm just saying, for our purposes, we're making such great time, I hate to spend unnecessary time, and we can maybe make a decision at 12:30 or 12:35, that's what I need to extend it, but does that make sense?
I'm good. I'm hopeful we can get.
Okay.
We will do a 20-minute recess. I'll amend my motion for a 20-minute recess. Do I hear a second?
Second.
Any discussion? Hearing none, I'll call the question. All in favor, say aye.
Aye.
Aye. All opposed? Hearing none, motion carries. Convene. We will, I get a motion to reopen the meeting. I'll second that. All in favor, say aye. Aye. All opposed, say nay. So the remaining agenda items we've got, first up, is Mr. Ritter. I think he's presenting for the consideration of adjustment to maximum contribution limits. Mr. Ritter, whenever you are ready, we are ready too.
Okay, awesome. Thank you very much. And I will tell you that item 8 actually could have been folded into the report of the executive secretary and item 9 because, strictly speaking, I don't think that action is necessary for the commission at this time. But let me tell you why I had to put on the agenda, and at least to give you background because it will come up again in our next meeting. So, Georgia statutes provide that at the end of the election cycle, the commission will consider raising or lowering the contribution limits based on the consumer price index. That's actually a difficult thing to assess as to when that election cycle ends because it isn't one election cycle in Georgia. An election cycle typically runs until, for a specific office, it runs until the election is complete for that office. So, for instance, we had an election that happened in November, and for many of those offices, it was the election cycle ended when there was no recount. And for some people, there was a recount. Some people are still contesting that. I think the chair may be familiar with that. So there are certainly issues out there as to when that happens. And then you've got municipal elections that have their own election cycles. So not long ago, the commission decided to enact Rule 189-1-2007, which provides that each calendar year at its first regularly scheduled meeting of the year, the commission will review the maximum contribution limits. That meeting is actually going to be our March meeting. But I wanted to make sure you were at least attentive to this and aware of this. The commission has not attended to this issue since 2016. I can tell you, we've looked at the CPI over the last 2 years. It was 1.9% in 2017, 2.2%, or it looks like coming into 2.2% or even a little bit higher for 2018. It's 4% over that 2-year period where the commission has not addressed it. And I will tell you that looking at the numbers, and I would like to thank Ms. Wetzel for attending to these numbers as well, I can tell you that what we see is that right now, based on prior raises due to CPI, statewide raise, well, there's 2 limits, but the high limit is $6,600. And if you adjust it for inflation, which may happen in March, the CPI would push it to you have to adjust in increments of $100. And that would push it to $7,000. And then the lower limit would be pushed to $4,100. That's for statewide. For other candidates, which are other state and local, for instance, House races and so forth, have a lot lower limit. And again, we're looking at probably about a $200 increase for the larger high limit, and the lower limit is looking at about a $100 increase. So with your permission, that's just really information, and we will put this back on the agenda for vote and consideration by the commission at that time. And we will include as well a brief report on the CPI to give you the numbers, to give you the specifics as to what we're doing. So
Okay.
it's just a heads up.
Good, thank you. And I think a report would be helpful just for,
Yeah.
because that's a fairly large decision, just to give the commission full information. But thank you, Mr. Ritter, that's very helpful.
Absolutely. Thank you.
And so, does that complete your report?
Yeah, I think it's number 8, and then I can go to executive session.
Absolutely. Report of the executive secretary. Please go ahead.
Okay, thank you very much. We try to make sure the commission is in the loop exactly with what we're doing. I can tell you that that didn't happen in the past, and I think you need to know the details of what we do. A lot of what we do is behind the scenes. You don't see it, receiving complaints. But the lion's share of what we do is filing and answering questions for folks and trying to make sure that the system is actually working. Robert and Bethany focus very much, of course, on investigations and audits, as well as supervising a host of employees, and I want to emphasize they do a great job. But the most important things that we do sometimes aren't seen, like providing training or trying to get the system working, which it typically does pretty well. And we're working on a lot of things for that. We've got an outside company that is completing a project that we have for improving our computer system as to late fees and certain filing issues. That's not a cure-all. I'll be meeting with the governor-elect tomorrow to discuss some of these issues and to bring forward both the issue of we need some dedicated money, not an increase in our budget overall, but dedicated money such as through a bond or a one-time allotment to deal with the fact that we could really use a better functioning computer system on the software side. Hardware, we got fine. That wasn't the case 5, 7 years ago, but now we have solid hardware, but we have serious software problems because there is no off-the-shelf stuff yet, and the maintenance has been sporadic, and for a long time there was none. So I'll be asking the governor to attend to that. There's also some issues with legislation. We discussed that briefly last week. I'd be delighted to work, as I said last week, with the Attorney General's office if you wish. But the most important thing is that we work with the governor's office and with the new elected officials to try to get the right laws in place. In the past, the commission has directed me to take control of that and take care of it, and I'm proceeding with that unless I hear otherwise. But I can tell you that all of these changes, from my perspective, anything that I would push would not be something that has a policy impact. That is to say, we're just trying to make the system work better. People talk about not liking red tape and bureaucratic problems. Well, I can tell you, there is red tape in this code that is unnecessary, regardless of the policy perspective. And it's just wasting the state's resources. We can make it work without it. And I've gotten some very good feedback on it, but every year, what's happened is that the legislator who is going to introduce it, because it has to be done by a legislator, will not allow me just to introduce legislation. So, but they haven't carried through with that for a variety of reasons. I'm hopeful we'll do better.
What are the reasons, just out of curiosity?
Well, last year was Wendell Willard, and the year before. And Mr. Willard and I worked before on a number of projects when I was at the AG's office. I represented the state in a number of constitutional challenges and laws that he had been behind. And he was head of the Judiciary Committee, so I dealt with him, and so I knew him. But he did not do very well last year. Frankly, just sort of went through the motions. We spent a lot of time talking about what it was going to be, but at the end of the day, he didn't want to introduce it. The year before, sort of the same thing happened. And I can tell you that he was, I think, policy-wise, he didn't have a problem with it. But his concerns were just that it was not high on his agenda. So we may not have had the right sponsor, even though he was the head of the Judiciary Committee and wanted to do it. I've spoken to the Speaker's office already, and the Speaker, we have a new Lieutenant Governor, I'm speaking to their office, but I'm certainly familiar with Lieutenant Governor's staff. For instance, Irene Moon, I saw her on the way back, and she gave me a big hug, and she's all like, good luck. So she will help smooth that if necessary. And again, we'll meet with the new governor-elect and see what we can do. Nothing in this is policy unless you directly want certain policy. Most of it is just, look, this isn't the right way to have this law written, and it costs the state money to do it that way. So that's going to happen. I can tell you that in terms of our overall numbers and so forth, just to go back to that for a moment, right now we have 7 hardship waivers that are being considered that we're waiting for more information on. Just so you know, since the members, hardship waivers work like this. Under the statute, which is 21-5-14, actually B14, C3, Roman numeral 3, so it's waived in there, is really where the meat of your authority is. And that allows you to waive if there is a hardship. So we have specific criteria and guidelines that we've had for several years as to whether or not there's a hardship. These have been reviewed several times, but what someone can't do is they can't just say, I think it's too much, I don't want to pay. Then we have to say, no, I'm sorry, that's not a hardship. You got to show us, you were sick and you couldn't file, or a host of other things. So we've got 7 of those pending, waiting for more information that would support a hardship waiver claim. But 93 cases have been addressed this year on hardship waivers. And the only one that was really one that we would even considered was the one with Mr. Halliburton, who decided, just, okay. So that was good.
What's the range, generally speaking, when someone applies for a hardship waiver? How much are we talking about, an issue? Let me ask it a different way. Is there a certain threshold under which we say, you know what, that's just too low an amount, we're not going to consider that for a hardship waiver?
No, we don't. But the hardship is, if people have an enormous amount of fees that are due, then we would consider their financial ability to pay.
Sure.
And I think we would transition in the future towards more of a, rather than a waiver, the code also gives the commission the authority to defer payment and have payment plans for some of those. But having said that, most of these are fees. And the fees for the ordinary campaign contributions still start at $25. And they go up periodically after we provide notice. And they don't go until you file. To answer Mr. Guido's question earlier, I'm happy to get into that, but paying the fee won't stop it from escalating if you don't file. You have to file to stop it. On the other hand, if you don't pay but you file, then it's going to stop raising. So, but for lobbyists, if they miss filing their bi-weekly lobbyist report during the session, it starts out at I think $275, goes up to an additional $1,000 on that, and then you add another $10,000 to that. Okay, so if you miss one of those reports, arguably you're in the hole for $11,275, which is a lot. And that's a fee. That's not a penalty. That's a fee. If you miss multiple reports, and some people sign up to lobby at multiple different levels, so they have multiple reports that are due, it can be substantial. And it's one of the things that can be administered better in the way that we'll discuss in legislation. But I can tell you that that we do see those. We will certainly consider those. But generally, a hardship is going to mean, and we see this not infrequently, someone had some sort of catastrophic illness or something like that, and just couldn't file. Or sometimes someone will say, I tried and I couldn't get on the system. Even though pretty much we know that's not true, because we can document their efforts and the system is available. I can show that the uptime on the system is better than 99.99%. But nonetheless, we are very deferential to that if they can show us it. And anybody who doesn't have their hardship granted can always take it from us to you and say, I should have gotten this. And at every meeting or so, you see 1 or 2 or 3.
Understood.
Okay. Yeah, no problem at all. I'm a lengthy answer. So anyway, that's where we are on that. I can tell you in terms of case management, we've had 143 cases filed this year. We've closed substantially more than that. close to 190 cases. Or we have 143 cases pending right now. And so we have 28 cases since the last meeting. And in terms of collections, you know, I can tell you that quite a lot of them, you know, in the $1 million range of collections. But, you know, again, I think the system, by improving particularly our computer system, our current fee system would actually substantially cover a lot of our costs if the system was changed so that we could actually collect fees more readily. I won't get into the details, but there's some very difficult issues with the way the law is written. I'm not sure to collect fees from local funds, that's at the county and municipal level. I've worked a lot with them, and I think that I've got GMA and ACCG on board with some sensible changes to this to make this work better. I can tell you the election filing clerks at the local level do not want the law to exist the way it is right now at all. And frankly, I agree with that. Because they do not need to be on the loop. That's a classic case of putting a cog in the machine that doesn't need to be there, because they don't do anything except receive them and send them to us, when people just send them to us to start with.
And we tried to change that one time, right?
And we're still trying. We're still trying.
But we got resistance from the GMA.
We did, but now they back down.
Okay.
We got resistance from ACCG, and now they're telling me they're 100%.
Okay.
But the difference is that I asked the filing clerks, since they were on our side on this, well, you need to let GMA and ACCG know where you stand on that, because they're not doing that, and I think they did. And GMA and ACCG certainly were. Okay. The GMA has one sort of sticking point, but I think it's a reading of the code for the code. Okay. So that's update on collections and so forth. Finally, on employees, we have not had that much employee turnover, and for a long time we had no employee turnover for the first several years in my position. We worked very hard to create a favorable and friendly environment for our employees. Unfortunately, we did have a couple of people who came on board who were not able to do the job. And that's sad, because we had some other people who were hired for the same position who could do fine. And we worked very, very hard with these folks to try to help them. But anyway, and we've also moved some people around to find a better fit in our office for folks with what they're doing, so that we'll have people doing the right tasks.
How many employees total on the part of the commission staff?
We have 17. So with that, and without further ado, I'd like to introduce you to two new higher level employees that we have. Okay. First in the back is Holly Smith. Holly is great. She is taking the position that was held by Maria Basile. And so far, she's doing a great job. And
What's that position?
that is our compliance and filing director. Yeah. Which means she oversees right now 4 people, but that will be growing probably. And in terms of filing and also doing some training stuff and answering questions. There's a whole host of things that fall into that jurisdiction. I'm afraid sometimes I scare Holly a little bit with my emails about this stuff needs to be done this way, and you know, it's a lot of stuff. But we're delighted to have her. And Holly, is there anything you'd like to say?
I'm just happy to be here, and I'm ready to get started. Yeah. Thank
All the
you.
commissioners are grateful for you. Thank you, Holly.
Thank you so much.
Holly, by the way, came from the Secretary of State's Elections Division, where she was a trainer, but just highly praised by everybody, but knows the local folks that do it very well already.
Very good.
And then, over here on my right is Kim Crowell.
Okay.
Kim's been helping us with the meeting today, and we are delighted, of course, to have Kim. Kim comes from the Lieutenant Governor's office, where she did a variety of tasks, but probably most importantly, dealing with citizens and their issues.
Constituent services.
Oh, wow.
Right.
I was an intern in constituent services once, and I'll tell you, that's a tough role. The amount of calls that I got,
Yes.
my cat stuck in the tree. I need you to come help me.
And what you gonna do about it, and I want you to do it now.
That's right.
Yeah. Mhm.
Good. And what's your role, Kim?
I'm the legal secretary and executive assistant.
Good.
Right. So she's assisting myself, Robert, Bethany, with our jobs, and we are delighted to have Kim.
Good. Well, the commission's grateful for you too, Kim. Thank you.
Thank you for having me.
That pretty much covers everything I have to say, and I appreciate your time.
Great. So I think that concludes. Is there anything else, Mr. Chalmers? Do you have a comment?
Mr. Chairman, may I make a public comment? And I wasn't going to do it before, but one of the things that Mr. Ritter just addressed about the contribution limits, I think needs to be addressed. And just to be clear for the record, I'm not making these comments on behalf of any of my clients. These are simply my observations as a public citizen, having practiced before the commission since about 2002. The purpose of the increase in the contribution limits for inflation is to be able to make it election cycle specific. That's why the statute says that after the election cycle concludes, the commission shall adjust the contribution limits based on inflation. Waiting until the March meeting to do that, because the commission a few years ago adopted a rule saying we'll take care of that at the first hearing after the new year, makes it difficult for candidates as a practical matter, because you're talking about having two different contribution limits at different portions of the election cycle. And in addition, it's also denying them the right to raise the increased amount of money now. The election cycle ended on the November election, with the exception of a few elections which are still being contested. The purpose of the statute was, as of that election day, to start with the new contribution limits. My understanding, based on the CPI, that the limits would be going up. So I would respectfully suggest that because candidates are trying to raise money now, between now and the start of the legislative session, that either the commission address that as required by the statute at this meeting and impose or establish those new limits and let candidates raise that now, or that when you do that in March, you make that retroactive. The problem with doing it retroactively in March is that it denies candidates, again, what the statute intends to be an increase in the limit after an election cycle for inflation. So I would respectfully request that you all consider that. The rule was adopted a few years back. I respectfully submit it's not consistent with the intent of the statute that it be done at the end of the election cycle. And it really isn't hard to do. There are very few actual limits. There are statewide limits and there are non-statewide limits. So there's really only 4. And the CPI calculation is not difficult either. I think it's actually already been done.
Yeah, well, thank you, Mr. Chalmers. And I also welcome Mr. Fuller, Mr. Ritter's comment. My concern with that, one option is to call a special meeting before the beginning of next year. My one concern is I would, and I don't even know if it's possible if it's not formally on the agenda, but like to have everyone an opportunity to the extent that they want to appear at the meeting and voice concern about moving the amounts up or down. But Mr. Ritter, do you have any comment on that recommendation?
First of all, I have no qualms about you doing it now if you wish to do it now. I don't know if my mic's on, but in any regard, I will say that what Mr. Chalmers has said, he said before, that we had a very, very lengthy colloquy with the commission at the time this regulation was adopted. And he raised those concerns and expressed his views as to the intent of the statute. But I can tell you that all the election cycles from the most recent election are not finished yet. And because there's still issues going on, it's appropriate to do it in March. I don't think it's a hardship to do it in March. There's no right to have it raised. All that said, if the commission wants to consider it now, I'd be happy to give you the numbers, and I can read them out into the record as we have them, but because frankly, it does not affect our job, other than we abide by the higher limit.
But the other commissioners have thoughts?
What's the rule?
The rule is 189-1-.07.
Is there any concern about the fact that it's not on the agenda today and our ability to vote on it? If it's not on, it's an indicator. My number one concern is I just want anyone who has an opinion one way or another to have gotten fair notice and an opportunity to appear and be heard. And that, my preference, I fully appreciate Mr. Chalmers' comments, and I think they do have legitimacy. It's just, I would prefer, unfortunately, we're running up on holidays, but I prefer to have a special meeting to the extent that the commission decided to address it before 2019. And I mean, Mr. Ritter, would it not being on the agenda as a formality create?
It is on the agenda.
Okay, so
I made it on the agenda.
Okay.
Right, and I put it on there specifically so that we could bring it up for your consideration, though as I began my comments with, I'm abiding by the regulation that were adopted, and the regulation says at the first regular meeting of the calendar year, and that would be our March meeting.
Wouldn't it require a rule change for us to vote on it tonight? No?
No, sir, because the rule, I'll answer that in two parts, if I may. First off, the statute trumps the rule. Oh, their right to raise money based on the number of the General Assembly rather than arbitrarily by the commission.
So then you can respect or appreciate my view as a lawyer when I ask you, has any court ever ruled on or interpreted this rule or the statute in the way that you're suggesting, that the statute itself is superior to the rule, and that we are therefore bound by the statute and that we don't have the discretion that the rule suggests?
I don't believe there are any Georgia cases that have interpreted either this provision in the statute or the provision in the rules.
Okay.
I think as a matter of general law, and I didn't bring a citation with me, frankly, I wasn't expecting to discuss this. There is case law holding that statutes are superior to and trump rules adopted by administrative agencies.
Okay. Thank you.
Yes, sir.
So I think that the commission just has to make a decision unless everyone to wait until March or make a decision today.
So, Mr. Chairman, if I may, and someone tell me if I'm creating work for people who already have too much work. I know my understanding would be furthered if we have a legal opinion on this question. I don't know if that comes from the Attorney General's office or if that comes from staff, or I'm not sure exactly where, but I'd certainly be more comfortable in making a decision. Given the arguments that we've had today, I think Mr. Chalmers makes some compelling points. I feel more comfortable if we have a legal opinion on it.
I agree with that. Mr. Fuller, is that something you could assist with, or what would be your recommendation?
Well,
You can meet me up outside, Mr. Fuller.
I'll stay away from the substantive discussion, just on the point of requesting an opinion. I believe, as with many agencies in the state, if that agency feels that there's a need for a legal opinion to be drafted by the Attorney General's office, that request can come. So that's something that the board can do if they, or Mr. Ritter. I mean, it's entirely the discretion of the folks to my right here to ask on us to do what you choose for us to help you guys with.
Okay.
If I could comment on that. If the board would like to have a motion and ask for a legal opinion to be requested, then I would make a written request to the Attorney General for a legal opinion on this issue.
Do we need a motion for that? It's not an official act of the board. Can't we just ask the Attorney General's office for a legal opinion?
Well, we do need a writing that asks for it.
Okay.
Okay, and I can make that writing. I can tell you that the way that the statute that gives them their authority to issue those opinions is drafted, I have asked for an opinion, and the commission has received, or the Attorney General's office has received opinions. I've drafted many, just from people in my position before. So, but I would want to act at your behest. So even if the sort of the will of the commission was to do that, I could do it. Once we make the request, and I can make it today, typically the AG's office, as a rule of thumb, turns those opinions around in 60 days. So we have it before our next meeting, but not much.
Have you ever used I'm just curious, and maybe you don't even have to answer this, but have you ever used this as a defense in a case, brought by the commission against one of your clients? The confusion created by the fact that there may be this 3-month delay in increasing the limits?
No, so the issue has not come up in any case in which I have represented the client, so I've never used that defense.
Okay.
I would just add, though, the requesting a legal opinion is tantamount to waiting until the March meeting.
I agree with
I
that.
know. Right.
All the commissioners have any other questions?
Yeah, I have a comment, Mr. Chairman. To me, it seems like there's kind of two issues. One is, I want to understand, maybe Mr. Ray, you don't understand my question. When we set in the past, when the commission has set the limit, it applies to that period of time that began with the end of the election cycle, the day after the election, or, because I understand Mr. Chalman's point is that when I raise the money, or when I candidate raise the money should be immaterial as long as it's within that cycle in which the cap applies. And I do understand that he's saying that if you were to raise money in December, one cap would apply, and if you were to raise money in, say, April, a different cap would apply. That's not what you're saying. You're saying that the same cap would apply for that entire period.
I can tell you that as a matter of practice, we have assumed that the limits apply from the point that the commission acts. But that issue has never been litigated, it has never come up. It's never come up in a way that would say, no, we need to go back and say there's a violation of $300 here because they raised $300 extra in this month from this one person. So that's never come up. But I will tell you that I want to emphasize, we've got no problem doing it however you direct. We will make it happen.
Well, to me, it's somewhat immaterial when whether you do it in March or December, because even in December, there's a lag from the end of the election cycle. Would you agree with that?
Well, you know, as a practical matter, we would look at it if we closely looked at that, and these cases typically are not within that margin of error. But if we had to closely look at that in the past, I can tell you that our understanding, maybe incorrectly, was that no, it doesn't relate back to the beginning of the election cycle. No, it's not retroactive. If you acted on March 15th, then every dollar raised after March 15th, it would be subject to. It would not apply to the amounts that you raised before March 15th.
I'm not hearing a disagreement between Mr. Ritter and Mr. Chalmers, and if I am, please tell me. Is there a disagreement between the two of you or the respective positions about whether or not the cap applies to an election cycle? Mr. Chalmers.
Commissioner, I believe that is the intent of the law, and I believe that any change should apply to the election cycle. Mr. Ritter is correct. The way it has been done in the past is different. It has been changed in the middle of election cycle and then only changed prospectively. Has not been changed retroactively. In addition, one of the problems with doing it retroactively, if you wait until March and then say back in December you could have raised $7,000, for example, if you're a statewide candidate, is that the ability of candidates to raise money changes during the election cycle.
Understood.
The time period right before the legislative session is legitimately a time period to raise money in part to cover previous debts and also going forward. And so I think that it's important also to keep in mind, and I won't repeat myself too many times, this is a right that they have under the statute.
And in my view, reading the statute here, the definition of election cycle, in my view, is unambiguous.
I agree with that.
And so the question is simply whether or not the cap applies, well, and I don't hear a disagreement that the cap applies to an election cycle. The question really is, when we act, the retrospective nature of our action, arguably, practically speaking, might hamstring candidates because of their ability to raise money during a particular period of time. That is not a legal question, that's a political one that I'm not sure we need to concern ourselves with.
It's a legal one in the sense that if you deny them the right to raise at the higher limits for any period in that election cycle, you are in fact denying them the right to raise money to which the statute grants them.
Are we denying them, or are we simply setting it at a period in time later than they would like?
The effect is the same.
Well,
I'm not sure I agree, but your point is well taken.
It's not when they would like.
Yes.
It's when they're entitled. The statute mandates that at the end of an election cycle, the limits be adjusted for the CPI. Straight numerical equation. The end of the election cycle has now happened. We're in the first meeting after the election cycle, and now is the appropriate time to adjust the limits as mandated by the law based on the straight numerical calculation of the CPI, or leave it the same.
But it says first meeting of the year, not of the election cycle.
That's what the rule says.
Okay.
Yes, sir.
Okay.
The way you read the statute, you actually think the statute would contemplate the change to take place the day after the election cycle.
I actually think that's the intent of the statute. And I
So
don't,
do you think
that would be the time, if the commission were to call a special meeting, that's when it should happen, the day after, to adjust the limits, so everybody knows going forward, yes or no is getting bumped up.
Based on your, just before I forget my thought, I'm sorry. Based on your mandatory reading of the statute, is it something that you feel like requires commission action, or do you think that it just automatically changes?
I honestly think it automatically changes, but Mr. Ritter is correct that the statute says the commission shall by regulation. And so the way I would interpret that having been applied is that honestly, if the rule had been drafted consistent with the statute, a regulation would have been adopted that says the day after the general election, the commission staff will calculate the CPI and post new limits on our website. It doesn't require a commission meeting to do that, but that's where we are now.
That's interesting. But that's not, if I could comment, that has not ever been the case. And that's not the way the commission chose to address it. It said by regulation in the statute. They adopted a regulation to square with that. So they're not acting inconsistently with the statute and adopting a regulation. If the contribution limits were to be retroactive to the first moment, 12/01/01, there are problems with that. For one thing, since the CPI will continue to raise or lower in subsequent years, when we reconsider this issue next year or in March of 2020, would we say then that all of a sudden, if we were going to raise it again, that rate relates all the way back, but that CPI wasn't higher at that point? And if I could continue on that thought, this year, 2018, we don't have the December CPI yet, even for this year. So it's consistent with that to have that CPI issued at the very first meeting of the next year. I think that's what they were thinking in saying it will be that meeting rather than the last meeting of the year where they consider it. Now, however you would say, but I could tell you that A, commission's acted by regulation. It's a lawful regulation, and B, if we follow that regulation, then it's our next meeting when we should consider this. And no, I don't think that's retroactive, but we will do something even to the point of if you would like to have a new regulation substituted for this one, we can do that. Because frankly, the staff doesn't have any skin in this game, so to speak. Let's do what you want.
What happens if is there a situation that occurs during this lag that we've got now? If the CPI goes down where you've got someone that's then, raised too much?
I think that, yes, sir, I think that you've got an issue there as well, which is why you need to change it the day after the election to make it clear to everybody what the CPI change was. And I think the CPI change, you don't have to wait until the end of December. You can go online and determine how much the price index has changed from one date to another. And in this case, you would look at from the last time there was an election to this election. How much has it changed? As a practical matter, one of the reasons it's gotten complicated because the changes haven't taken place when they were supposed to. And so now, if Mr. Ritter is correct, that does complicate the issue because now you have to go back and figure out how much has the CPI changed since the last time in the middle of an election cycle that we changed the rate. In addition, Mr. Ritter has gone back 3 or 4 times to the comment that the regulation was validly drafted. I think that's moot. Whether or not it was validly drafted, it specifically says that you have the discretion, even if it's a valid regulation, to vote at any time. So the regulation does not prohibit you from voting now to change the CPI. The regulation is largely moot.
Is it fair to say if you could kind of craft a solution, you might suggest that we call a special meeting the week after an election? then we'd be having special meetings all the time because tons of election cycles, right?
No, sir, that's not right.
That's right.
I don't, yes.
Go ahead, Mr. Chalmers, go ahead.
The answer is that as we were talking about before with Commissioner Kreinvold made the point, I'm not sure you need to have a meeting. I think you could, in fact, do this very easily by having the staff change the regulations, or excuse me, change the contribution limits the day after an election cycle for the changes in the CPI. If in fact you decide to have a special meeting, there would not be that many special meetings because there are not that many election cycles. Typically, either you'll have for a judicial election, the primary election is the end of the election cycle because they don't go on to the general. Then after the general election in November, you have a change. You are always going to have the situation with certain special elections. You could argue that, well, the special election for House District 75, now you have to call a special meeting after the election for that House seat to change the CPI for that House seat. I don't think that's the intention. There's really only two limits you have to ever apply. A statewide limit and the limit for everybody else. There are only two limits in the code section. So I think that, you know, you would, if you had to call a special meeting after the general elections, you could do that by telephone. The staff says the CPI went up 3%, the new limit should be X. You say, motion to approve, done. So it would be pretty easy to do even if you had a special meeting.
All right, but to keep it going and being respectful of
Yes, sir. Thank you
everyone's
for your
time,
time.
all of these are great points. My thought is that there's definitely some ambiguity here. And I appreciate and agree with Mr. Barnum's earlier suggestion that maybe we should get an formal AG opinion because it'll probably be the most efficient route. Based upon their recommendation going forward prospectively, we can start addressing it with either in line with that recommendation, but definitely in consideration of Mr. Chalmers' comments and Mr. Ritter's comments that will punt it until March, but that will also potentially address any notice considerations to make sure that it's formally on the agenda that says it will be voted on. So with all of that, I would move that we request the Attorney General to give an opinion, and I don't know how we would label exactly what we're requesting. Mr. Ritter, would you recommend putting that in the motion itself, or?
No, just, if you just have me, if you were to move to direct me to request an opinion from the AG's office on the matter of the contribution limits that we've discussed, I will write an appropriate and fair-minded letter to ask for that. Short and sweet.
Okay.
Okay?
So
And I'll be happy to submit it to you if you want to review it first.
Yes.
perfect. So I will move that we direct Mr. Ritter to submit a request for opinion to the Attorney General's office on this contribution change issue subject to the Commissioner's review. And then we will vote on the maximum contribution changes at our first meeting of 2019, which will be in March. And that's the Chair's motion.
Seconded, and Mr. Chairman, I offer a friendly amendment to the motion. Can we also agree that if we feel there is a need to call a special meeting before the March meeting, we'll do that?
Sure.
To address specifically this issue.
Yeah, and I'll second that amendment. So any discussion? Hearing no discussion, I'll call the question. All in favor, say aye.
Aye.
All opposed, say nay. Hearing more ayes than nays, the motion carries. So I think that concludes our meeting, except for the amendment which added the executive session. We went through, and correct me if I'm wrong, Commissioners, is there any remaining items? I know that we expedited, moved up some of it. Okay. So, Mr. Fuller, your recommendation for initiating the executive session, is that take a motion and a second approval by the Commission?
I believe it does.
Okay.
Mr. Chairman, I move that we move to executive session specifically to discuss personnel matters.
I'll second that motion. Any discussion?
May I offer a comment, Mr. Chairman, that we, as we give our reason for the executive session, that we cite the OCGA 50-14-3 exceptions to the Open Meetings Act. As the view.
And I accept that, and I would say, so 50-14-3, 2 and 3.
And,
I think it's 2. Yes. Let me just, 50-14-3, and that is B2, is the section of the statute under which we are proceeding to executive session.
I agree. And I'll second that with one discussion comment. Mr. Fuller, do we need to make any permutations as far as if we request just the commissioners to be a part of the meeting?
I'm not sure.
Not in the motion?
I don't think so.
Okay. Okay, well then, I second it. Any other discussion? I'll call the question. All in favor, say aye.
Aye.
All opposed, say nay. Motion carried.
Okay, we're going to call the meeting back to order. The commission has completed its time in executive session. Chairman Evans had to leave. He has tasked me with closing the meeting. Before I hear a motion for adjournment, is there any other comment or anything?
This is the last meeting of 2018, unless you have a special meeting. And typically, at that last meeting, you discuss an open meeting and set the dates for the next year's 4 regularly scheduled meetings. That way, we're on track with having regularly scheduled meetings, consistent with the Open Meetings Act.
And this was not any effort to exclude you from that. We actually covered some agenda items while you were in transit back from the office.
Oh, okay.
And we've got those for you.
Oh, great. Okay, thank you.
We've got March 28th, June 27th, September 26th, and December the 4th. Those are the dates that we reset for 2019.
Got it. Thank you very much.
Anything else? Okay, do I hear a motion? Move to adjourn? Second? Seconded. Any discussion? Call the question. All in favor, say aye. Aye. Any opposed? Meeting adjourned. Thank you. Thank you, everyone.
Thank you.